Welcome to the deep dive. Today, we're really getting into something significant, a groundbreaking ruling.
Yeah, from the Ninth Circuit Court of Appeals, no less.
Exactly. And it has these huge implications for, well, a fundamental right, the right to open carry. So this deep dive, it's all about the Young v. Hawaii case. We want to unpack what this ruling really means for you.
What its impact is right now, and crucially, what might happen next. It's a complex legal picture.
Right. Our mission is just that. Break down this complex stuff, figure out the immediate effects, and, look down the road a bit.
It's definitely a big development, especially, like you said, coming from the Ninth Circuit. Many people see that court as, well, challenging for these kinds of cases.
We're going to dig into the specifics, this long battle, and, the potential ripple effects across the country.
Yeah.
But I think the first thing on everyone's mind is, okay, what does this mean practically, like right now?
Right. Does it just open the floodgates?
Yeah. Is it, suddenly okay to carry openly everywhere in those states? Or is it more complicated than that?
It's almost always more nuanced than the headlines suggest. That's what we need to clarify.
Okay, so let's clarify. We're here to sort out what's real, what isn't, maybe bust a few myths.
Exactly. The initial reactions, they often swing to extremes, but legal rulings, their actual rollout, much more involved.
All right. So the big news itself, a 3-judge panel, Ninth Circuit, upholds open carry as constitutional. But this wasn't quick.
No, not at all. This has been a long road. 6 years for the legal team, but even longer for the plaintiff, George Young.
Tell us about him. His dedication sounds pretty incredible.
It really is.
Right.
This is actually his third case trying to assert these rights.
Third, wow.
Yeah. He'd filed after the Heller decision in 2008, the one establishing the individual right for self-defense.
Right, and McDonald, which applied it to the states.
Exactly. Those earlier cases got dismissed. So he filed this current one himself, pro se initially, without a lawyer.
That takes serious persistence. So how did the legal team eventually get involved?
Well, after his case was dismissed at the district court level back in 2012, Alan Beck took it up pro bono, filed the appeal to the Ninth Circuit late that year.
Yeah.
And then I joined as co-counsel in October 2015. So yeah, it's been over 6 years for us, and even longer for Mr. Young himself. A real marathon.
What makes this Hawaii situation stand out is their whole permit system, right?
Yeah.
Like, the law says one thing, but...
Yeah. That's really the crux of it. Hawaii's laws, if you read them, they theoretically allow for both concealed and open carry.
Theoretically.
Right. But in practice, they issue basically 0 permits, none.
And they admitted that.
Their own attorney did, yes.
Yeah.
During oral arguments, you can't have a law saying something's allowed and then simply refuse to ever grant the necessary permission. It makes the right totally meaningless.
It really highlights that a right on paper doesn't mean much if you can't actually exercise it.
Exactly. It reminds me a bit of the situation in D.C. for a long time. Finding someone with a D.C. carry permit used to be like finding a unicorn.
Though that's changed a bit now.
It has, yeah. Now there are about, 1,600 active permits in D.C.? But for years, it was practically impossible. Hawaii was like that, but even more absolute. 0 means 0.
So, given the Ninth Circuit's, let's say, reputation on gun issues, how did this win happen? What was the key?
Honestly, the law was just clearly on our side on this point.
Simple as that.
Pretty much. Hawaii had this law in the books allowing carry, but their policy was just blanket denial. They weren't following that own law. That made the legal argument relatively straightforward, even in the Ninth. They'd essentially written the right out of existence through administrative action.
Okay, so this feels quite different from the Peruta case, another big Ninth Circuit decision. Can you remind us about that one and how Young compares?
Right, Peruta. That one was interesting. Initially, a panel did find a right to concealed carry, but then it went on ban. The larger 11-judge panel reviewed it, and they reversed it. They said there was no Second Amendment right to carry concealed outside the home. Crucially, though, Peruta deliberately avoided the question of open carry. They focused only on concealed.
So Young tackled what Peruta sidestepped.
Exactly. Mr. Young's lawsuit was broader. He sought the right to carry openly concealed, plus knives, stun guns, tasers, the whole spectrum. So it forced the court to address the open carry question head-on, which Peruta hadn't. That makes this Young ruling really significant.
Okay, a significant ruling. But back to the practicalities. Can people, start open carrying in Hawaii tomorrow based on this? What's the actual status?
Right now, no. The decision is effectively on hold. The legal term is stayed. The court hasn't issued its formal order, the mandate, yet.
So it's in legal limbo for the moment. You can't act on it.
Correct. It's not immediately actionable for anyone right now.
And what's Hawaii likely to do next? They're not just going to accept this,
Right.
presumably.
Well, the county of Hawaii asked for more time. They got an extension until September 14th to decide whether to file a petition for a rehearing.
A rehearing, what does that involve?
It could mean asking the same 3 judges who just ruled to reconsider. Or they could ask for that en banc review, like in Peruta, where an expanded panel of 11 judges takes another look. That usually happens for really important cases or if there are conflicting rulings within the circuit.
This feels like it could head towards the Supreme Court.
Yeah.
What are the sort of strategic implications there, like a legal chess match?
It absolutely is. Think about the game theory, right?
Go.
Scenario 1. Hawaii decides not to fight it further. Maybe they think they'll lose again, or maybe they don't want to risk a bigger ruling. If that happens, this Ninth Circuit decision stands. A right to open carry outside the home becomes the law in the Western states covered by the Ninth Circuit.
Okay, that's big for those states. What's scenario 2?
Scenario 2. They do contest it. They petition for rehearing. Maybe you lose again and then appeal to the Supreme Court. Or maybe they win rehearing en banc, and then we appeal. Either way, it could reach the Supreme Court.
And if the Supreme Court takes it, that needs 4 justices to agree, right?
Correct. If 4 justices agree to hear it, then the court could potentially issue a nationwide ruling. And they might not just rule on open carry. They could potentially address concealed carry, too.
Yeah, wow.
Well, that would certainly irritate places like New York, California, other states with very restrictive laws.
So for gun rights advocates, getting it to the Supreme Court might be the bigger prize, potentially.
It's the path to the broadest possible clarification, yes, a nationwide standard.
Does the current makeup of the Supreme Court, maybe Justice Kavanaugh's confirmation, affect the chances of them taking a case like this?
It very possibly could, yeah. There's what lawyers call a circuit split right now. You've got courts going different ways on this.
Like D.C. versus Hawaii, California.
Exactly. D.C. is now effectively they have to issue permits if you meet the criteria. But Hawaii and California after Peruta are much tougher. Essentially, may issue or even no issue in practice. That kind of direct conflict between circuits, that's often a key reason the Supreme Court steps in to create uniformity. So yes, the current court might be more inclined to take up such a case to resolve that split.
So playing this out, for those pushing for expanded gun rights, what's the absolute worst outcome here?
Honestly, the worst case is probably just the status quo, no change. Things stay as they are now.
Which isn't the goal, obviously.
Right. The goal is to ensure people can defend themselves outside the home. The Heller decision said the right is most acute in the home, but that implies it still exists outside the home, doesn't it?
Logically, yeah. Can't be most acute somewhere if it doesn't exist elsewhere.
Precisely. It presupposes the right extends beyond the doorstep.
Okay, that makes sense. Now, you mentioned Mr. Young's case included more than just firearms, knives, tasers. This fight is broader than just guns, isn't it?
Absolutely. It's about the right to bear arms, plural. And what constitutes an arm for self-defense is part of the battle.
So things like stun guns and tasers. There are legal fights over those, too.
Definitely. We've filed cases specifically on those. There's one still going in New York where people can't even possess them in their own homes.
Really? Even at home?
Yep. New Jersey, on the other hand, folded pretty quickly when challenged. And as I said, they were part of Mr. Young's original challenge in Hawaii, too.
And the argument is basically about choice, that people should be able to choose their self-defense tool.
That's the core of it, yes. Not everyone is comfortable with a firearm. Maybe they prefer a taser or a stun gun. They should have that option for protecting themselves.
You mentioned a difference between stun guns and tasers earlier.
Yeah, it's an important distinction. A stun gun requires direct contact. You hold it against someone, zap them. They usually recover fast, and honestly, it mostly just makes them really angry.
Like mad as hornets.
Yeah, exactly. A taser, though, shoots projectiles, probes, that deliver the electric charge from a distance. More effective for incapacitation.
Okay, so what else falls under arms? Pepper spray, bear spray, a big knife.
Well, pepper spray can be considered an arm, yes. Bear spray, interestingly, is regulated by the EPA, but it's certainly usable for self-defense. And yes, even something like a machete is generally considered an arm. Even in New Jersey, that's recognized.
So is there anything that's surprisingly not considered a protected arm?
Yeah. There's one funny little exception that came up in case law. A paring knife.
A paring knife, like for fruit.
Exactly. The court decided its main purpose, its utility, is culinary, not self-defense, so not protected under the Second Amendment.
That is specific.
Yeah.
Okay, what about the other end of the spectrum? Machine guns. Any clarity there?
There have been cases, yes. In Texas and Pennsylvania, courts ruled the Second Amendment does not protect machine guns.
And the reasoning?
The reasoning was basically that they are not weapons in common use by civilians for lawful purposes like self-defense. And the court said it's permissible to ban them before they potentially reach common use. So those cases were losses for Second Amendment advocates.
Okay, so defining arms is one battle. But even when you have a right to own something, like, say, a suppressor, actually getting it involves navigating a whole lot of bureaucracy, right?
Oh, absolutely. The frustration with the existing laws, especially the National Firearms Act, the NFA, it's immense.
I mean, like the wait times for suppressors?
Exactly. You file your Form 4, pay your tax stamp, and then you wait. 8 months, 10 months. It's a long time.
But there's an even bigger issue you've encountered with the NFA process. Something about appeals.
Yes, and this is really concerning from a due process standpoint. The FBI, which runs the background checks, the NICS checks, even for NFA items, their formal position is that they will not process appeals if you get denied an NFA item.
Wait, really? Even if you think the denial was a mistake, no appeal.
That's their stance. They run the check, ATF gets the result, issues a denial if it's negative, but the FBI says we don't handle appeals for these, even though they're the ones who ran the check that led to the denial.
That sounds fundamentally unfair. How can there be no way to challenge a potential error?
It's a huge due process violation in our view, which is why we actually sued the Attorney General over this. The case is Umbert v. Jeff Sessions.
And what was the basis for that suit?
We had multiple plaintiffs, I think 8 initially. Some were denied suppressors, even though they are not prohibited persons. They're legally allowed to own guns, pass background checks for regular firearms, but got denied the NFA item and then hit this brick wall with no appeal process.
It really sounds like a system designed to be difficult, almost nonsensical at times.
It often feels that way. I mean, think about it. Why is buying an NFA item so much more complicated than, say, buying a federal duck stamp at Walmart for hunting? That's a federal tax stamp, too. Why can't a Class 3 firearms dealer just affix a point-of-sale stamp for NFA items?
That's a good analogy. Instead, it's this months-long process with potential dead ends.
Right. Or consider this absurdity. ATF agents, the very people who regulate firearms, they still have to undergo FBI background checks to buy guns themselves.
Seriously?
Yes, and sometimes they actually get denied. An ATF agent denied a firearm purchase, and then they also have to pay taxes on items that are tax dollars already paid for. It's just the system isn't built for logic.
How do you even begin to fight that kind of systemic issue, or at least bring it to light?
Well, one tool we use extensively is the Freedom of Information Act, FOIA.
To get government documents.
Exactly. For instance, I used FOIA to get the full court-martial records for the Texas church shooter.
And what did that reveal?
It revealed that the Air Force completely failed to report his disqualifying information into the NICS background check system. That failure is why he was able to legally buy the guns he used.
Wow. That's a critical failure.
It is, and my commitment is to put these FOIA documents online, make them public. So you, the listener, anyone, can read it directly. You can see the raw information and, come to your own conclusion about what our government is doing or sometimes what it's not doing. Transparency is key.
So the bottom line on navigating these systems seems to be it's not designed to make sense.
Pretty much. It often feels like it's designed to trap people, or at least make exercising your rights as difficult and complicated as humanly possible. Unfortunately, that's kind of where we are.
It's like the bureaucracy itself becomes the barrier, maybe more effective than an outright ban sometimes.
That's a really good way to put it. Bureaucratic hurdles can absolutely erode rights just as effectively, maybe even more subtly, than legislation.
Well, this has been quite the deep dive. We've covered the Young v. Hawaii ruling, the broader fight over what arms even means, and these really frustrating bureaucratic battles.
And it's important to remember these aren't just abstract legal theories. They have real-world impact.
Right. They affect whether ordinary people, average citizens, feel they can legally and practically defend themselves, both inside their homes and, as we've discussed, outside them too.
Yeah.
And it sounds like the driving force behind these long legal fights, pushing these cases as far as it takes, as you said, it's really a fundamental belief.
It really is. It boils down to the belief that you, as an individual, should have the right to choose how you protect your own life.
Ensuring that the rights we think we have on paper actually mean something in the real world.
That's the goal, making theory into practice.
So maybe a final thought for everyone listening to mull over after this deep dive.
Okay.
If a government can effectively deny a fundamental right, not by banning it outright, but just by creating impossible administrative hurdles, endless roadblocks, what does that tell us about the real nature of the rights we think we possess?
What does it really mean for a right to exist in theory, but be essentially unavailable in practice?
Exactly. It's definitely something to think about long after this conversation ends.